matter of Kostal UK Limited and Dunkley and others.
Yes, Mr. Burns.
I'm here for Kostal UK Limited today with Ms. Hirsch. Hoping he appears, and I have disgraced myself because I was introduced to his junior a moment ago. Mr. Gill. Here's Mr. Griffin. Apologies. This is an appeal from the Employment Appeal Tribunal against the judgment of the Employment Tribunal, which found that workers who were members of the Unite Union were made offers by Kostal, which, if accepted, would have the prohibited result for the purposes of Section 145B of the Trade Union and Labour Relations Act of 1992. And that it was Kostal's main purpose to achieve the facts, very briefly, are that Kostal is a electronics firm with about 700 employees. About 55 of those were members of Unite, the union at the time, employed as shop floor or manual workers. Following a request from Unite and a ballot, which was very much in favour, a recognition and procedural agreement, a collective agreement, was entered into between Kostal and the union. It's in the supplemental bundle, which I'll probably show you at the moment because we need time. It's page 50 of the supplemental bundle, and this is the agreement under which all of the Kostal workers have the right to have their terms and conditions determined by collective agreements negotiated by on behalf of the union.
Would that apply irrespective of whether the individual employee was a member of the union?
Yes, so Unite bargains, it has members, but it bargains on behalf of the bargaining unit, and all of the members, all of the workers in the bargaining unit are affected by the recognition agreement.
And was that because there's, as is often the case, there's some kind of term which incorporates the terms of collectively negotiated terms and conditions into the individual contract?
Yes, effectively, it wasn't a written term as I understand, but effectively in early 2015, Kostal agreed that for all of those within the bargaining unit, terms agreed collectively with the union would be incorporated into the contracts of employment of its workers.
Do we find, therefore, a definition of bargaining unit in the recognition and procedural agreement?
We don't.
If it's accepted that it just
yes,
is, then that it includes the non-union worker, because I'm happy to accept that.
Yes, the definition, I say, it's section 2 on page 51 is the scope, and 2.2 is the scope that will define, which is why I said that. The union will have sole recognition of bargaining rights, and the scope is the agreement applies to companies' employees working in all offices and buildings which form part of the UK's operations based at Goldport, and any subsequent transfer locations and the date of commencement doesn't apply to executive management. So it appears that all employees, the bargaining unit was all employees at Goldport, but not management.
Yep. Thank you.
Just looking at what the Kostal agreed to, paragraph 52, page 52, as with many collective agreements, paragraph 3.1 makes it clear that the collective agreement is binding in honour only and does not constitute a legally binding agreement. That's a statutory presumption. But as my Lord Justice Singh pointed out, effectively contractual effects can be given to collective agreements, normative effect, if they are incorporated by reference into a legally binding contract between employee and employer.
Do we have a specimen individual contract?
We don't, and the reason for that is that this agreement is early 2015, and the dispute took place in late 2015, and I don't know this, I can check behind me, but I suspect that new contracts of employment were not issued to the workforce in that time. In fact, this was the first collective bargaining round to look at how contracts would move on beforehand. So effectively it was agreed between the union and the employer expressly. The workforce had voted overwhelmingly in favour of recognition, not just the 15 odd Unite members, but 500, over 500 of the 700 have voted in favour of a recognition agreement with Unite. And so the company proceeded on the basis that the workforce was behind the recognition. You will see that the general principles are three, then there's some relevant parts relating to representation. The part that we're in, at the time of facilities, the point that we're interested in is negotiation and consultation committee, which is at page 55, paragraph 7. And that provides at 7.1 that formal negotiations will take place between the parties on an annual basis. This time, the company and the union will also agree to a member verification check with ACAS prior to negotiations commencing. Normally commence in October with a normal effective date of 1st of January. So the union and the employer agree that the negotiation window will be between October and agreement will be reached, presumably by December, so that the put to action by 1st of January. And any pay rise can be put into the January pay package. The Trade Union Negotiating Committee will be selected from the Trade Union representatives, maximum of 5, cross-section departments. And 7.4, the critical passage for the purpose of this appeal, any matters relating to proposed change of terms and conditions of employment will be negotiated between the company and the union. And then termination of this agreement, that agreement is on page 6. So, Lord Lady, you may be aware that some collective agreements are about pay, hours, holidays only, are limited to some terms and conditions. This collective agreement is to apply to all terms and conditions. So that is the
although there were only 55 members of Unite, that applies to the whole workforce other than executive management.
yes.
And the 645 non-members, or whatever the figure is, benefit from the efforts of Unite without having to pay a subscription.
They do, although of course if they want to influence the negotiating position of Unite, they have to join the union. And it is advantageous to a worker in a employment where the union is recognised to join the union, so that that individual can make his or her voice heard. Maybe the union decides to take its own course, or whatever, but if you're not a member, it's unlikely that the union representatives are going to be listening to you in devising their strategy for pay negotiations or the other negotiations on terms and conditions. It is common in recognised employers for there to be a bargaining unit which is made up of partly of members of the union who are recognised, partly of members of other unions, because somebody may be loyal to a union and moved into that workforce, taken a job, been transferred in and stayed with their existing union. And sometimes you have workforces, beware, where there is 2 or more big unions with a lot of members, and then there can be tension between which one has the whip hand, which one is better placed to get a better deal for the members, and sometimes there can be disputes between the unions as to which tactic or what should be asked for in any negotiating round. And there are also examples, one in which I was going to tell you about later, I'll mention it now, as an employment tribunal that I'm aware of coming up in a couple of months, where you have a workforce where you have 3 recognised unions. It's Unite, GMB and Unison, something like that. And so all unions have a seat at the negotiating table, and in that case 2 of the unions agreed with the employer about what the pay increase was to be. One union didn't agree, and the 145B claim that's been lodged is by the members of the union that didn't agree, because the employer made the offer to everybody in the bargaining unit, and the union said, right, well, you've made an offer that's a bit unlawful under section 145B because it was not negotiated by us, and our members have lost out because of that.
Can you just say again what the setup is there? Were there three separate documents like this, or one document to which more than one union was a party?
I think you're getting the information.
Yes. Three separate documents in that case. There can be, of course, an overall collective agreement to which three unions are party, but it is quite common for the unions to negotiate separately and then come to the table together. But I mentioned that we will be looking later at the hypotheticals for one interpretation of section 145B, what I've labelled for convenience the immediate interpretation, and what I've labelled the future result interpretation. Those are just my shorthand to make it clear for which interpretation the Employment Tribunal and the Employment Appeal Tribunal have interpreted section 145B, what we call the immediate result interpretation. We say that the correct one should be the future result interpretation. So, just to finish off the intro, sometimes what's called a joint negotiating council, or JNC, which a number of unions will come and negotiate together collectively with the employer at the same time, each pushing forward the interests of their members, but the collective agreement that's reached, if it's reached with all of them, will apply to all of the workers in the relevant bargaining unit. And my lord and lady, you'll be aware that collective bargaining is generally voluntary, but it can be compulsory, and there is a procedure which is looked after by the Central Arbitration Committee, where the union can, by showing a series of threshold steps, require an employer to recognise it for the collective bargaining for 8 hours and holidays.
But was this, in our case, was this a voluntary?
This is a voluntary agreement.
Yeah. Even so, the ballot didn't take place under the statute. Or it did? I think your junior is nodding that it did.
What often happens is that the union make a request for recognition. If the employer says yes straight away, then the voluntary agreement is reached. If the employer doesn't say yes straight away, then a series of steps, and at any stage along the way, the employer can say, I now voluntarily agree to collective bargaining.
Yes, I see.
Sometimes the employer says no right at the end, and the CAC then makes a direction and order and imposes a standard collective bargaining model, which is a statutory model, but in this case, as in many, once the employer sees the way the wind is blowing, they devise a collective bargaining agreement which is bespoke for their setup, which is good for both employer and employees.
Yes, I see. Is there anywhere, either in the statute or perhaps in a decided case, which tells us what the legal effect of recognition is? In other words, is it a right to compel the employer to come and negotiate, or what is it?
Until this case, it's been a right to be heard, a right to be consulted, a right to be negotiated with. And as I say, the result of the EAT decision in this case is that section 145B turns it for the first time into a right to prevail. A right for the union to say, you, the employer, may not make a change to terms and conditions of employment without our consent. Because if you do, you either will be fined £4,000 per employee, or, my second case, you at least risk it. So, do you want to take the risk? And so, in another realistic hypothetical example, we have a very large employer like the Royal Mail, 100,000 employees, and let's say that they have a dispute with the unions, so they had only 2 or 3 years ago, and it is intractable. Agreement cannot be reached on how to change the pension, defined benefit or defined salary pension scheme. And so the employer says, well, I'm going to impose a change. I'm going to offer this to all of the employees, and it's not something the union agreed with. Well, at that point, the employer has to factor in a £4,000 per employee liability that if, as I'll come to show you, an employment tribunal does not agree that the employer had properly exhausted collective bargaining and had a proper business purpose for making the offer, then that would be, in that case, 100,000 employees, £40 million potential liability, which, of course, would wipe away all the benefit that the employer might get from making the changes. So it's a very big shift, I said to the EAT, and I say now it's a paradigm shift in the relative strengths of the employer and the union in a unionised, recognised workforce. And we say, and we'll look at Article 11 of the European Convention of Human Rights in Wilson and in the RMT case, which we say makes it clear what the limits of Article 11 are. It is only a right to be heard, a right to be consulted, a right to be negotiated. It is not a right to prevail.
Is that where we're going to find what the effect of recognition is? It's not set out in the 1999 Act, for example. Is that right? Or in the 2004 Act?
The effect of recognition. The effect of recognition is not a legal or statutory concept. The effect of recognition depends on the terms of the recognition agreement between the employer and the union. So a union can be recognised for limited purposes or for extensive purposes. And so we don't have a legal concept of result of recognition because you could be recognised just for consultative purposes. We will not be deciding terms and conditions with you, the union, but we will, before we make a change, tell you what our proposals are. We will allow you time to consider those and come back to us, and we will take into account what you say, and then we'll go ahead with it or change it. So you can be recognised for consultative purposes. You can be recognised for collective bargaining purposes, which is what we have in this case, which is that the unions and the employers meet to discuss changes to terms and conditions with a view to reaching an agreement. And collective bargaining fails when at the end of that process the union and the employer cannot find common ground. And one hopes that the union and the employer would find common ground at the end of it, but it doesn't, as we know in the real world, always happen. Yes, I pointed out here that the effect of recognition is the working out of what is in the collective agreement that sets up recognition. So it can be very extensive, it can be very limited. It depends on what the recognition agreement is. In this case, we have recognition agreements which provides that all terms and conditions will be negotiated with the union.
With the union as sole bargainer.
The union and the own. So another union comes up and says we would like to be involved. The employer has to be a breach of the recognition agreement. It says yes, you can come to the table as well. What happened in the Kostal case was that in October, as envisaged by the recognition agreement, pay negotiations commenced. They continued through November. Pay offer on the 24th of November was for 2% increase for the workers in the bargaining unit, plus a Christmas bonus, which was equivalent to another 2%, and there was an additional increase for those employees who are earning over a particular threshold of £20,000. And in return for those increases, Kostal put forward a reduction in sick pay to SSP for new starters, a reduction in the overtime rates, and the consolidation of 2 15-minute breaks into one 30-minute break, presumably because under the working time regulations, workers are supposed to get one at least 20-minute break in the middle of their shift. They weren't getting that. They were getting two 15-minute breaks. And there was a proposal to consolidate that into one compliant 30-minute break. The final pay offer, that 24th of November offer was not recommended by Unite to the workers and was rejected by the ballot of the union members.
So that's the 55.
55 or so. I mean, I say
Thereabouts.
Thereabouts. There were 55 claimants. There may be a few more, maybe a few less, depending on.
But the 55, the claimants in this case, aren't just a sample of, say, 400 or 500.
Well, yes. I think
Members.
because Section 145B is effectively a free money claim, when you ask the union members who would like £4,000,
No,
you would
sorry.
expect them all to say,
Yes.
yes, I'll have a share of that, please. So there were at least 55 union members, probably not that many more, but maybe some more. And Kostal then said, well, our German parent company insists that we pay Christmas bonuses out of our 2015 profit. It has to be in the December pay. So they then made the offer, which is said to be unlawful offer. And that's in the supplemental bundle to page 46.
Just pausing there, Mr. Burns. The ballot is held of the Unite members by Unite,
Yes.
but of no one else. And was that because the rules of the union require them to do it? It's not a statutory requirement, is it?
No, it's effectively what I alluded to earlier, that if you're a member of the union, you get to
say.
influence the bargaining, so you get to vote on the deal. If you're not a member of the union, then you don't get that entitlement.
And on the claimant's case, the other 645 are effectively bound by the result.
The union depends on the union's rules, but often the union will not be formally bound by the ballot of its members, but will be often influenced.
No, I understand that.
But
But
the rest of
if the Unite negotiating team understandably pay attention to the result of their members' ballot, what the 645, who some might say should have joined but didn't, they cannot be encouraged to accept the employer's offer against the wishes of the majority of the 55.
So, two things. First of all, if the majority of the workforce want to influence what the negotiating team say, then it's absolutely their right and duty to join the union and to make their voices heard. If they don't, they have to go along with the result. Section 145B makes it unlawful to make an offer to a member of a trade union. But it doesn't make it unlawful to make an offer to somebody who's not a member of a trade union. So one option, one Section 145B compliant option, would be to make the offer to the non-members, except that the employer normally doesn't know who members are, because unions are rightly cautious about revealing union membership as protected data. So the employer could say, this is an offer we make to everybody, but you're only allowed to accept it if you are a non-member of the union. If you're a member of the union, sorry, we can't make this offer to you. And therefore could make an offer. That would lead to two problems. It would lead to a two-tier workforce, potentially. And the other thing it would potentially lead to is the union saying, you've done that as a detriment
Yes.
to union membership. So it wouldn't be a 145B, it would be a 146 claim. And they'd be saying,
Yes.
you've done that not because of business reason, but in order to penalise people for not being members, for being members of the trade union. So that is fraught with danger too. So section 145B conundrum has no, for a big unionised employer, has no easy out at the moment on the basis of the EAT's judgment. The best that the employer can do at the moment on the basis of the EAT judgment is tried to go to the Employment Tribunal and convince the Employment Tribunal that it has what the EAT termed a good business reason, or rational and reasonable purpose for making the offer, which somehow from the EAT takes it out of section 145B and take the risk. But let's look what happened in this particular case, if I can, with Kostal, and I was going to take you to page 46 in the supplementary bundle to see what is it that is the offer. And there's two offers. The tribunal found and the EAT found that two offers, these two awards, and there's no appeal against that. And so the question is, was this offer, and the one that followed it, an offer which falls within section 145B, an offer which achieves the prohibited result, i.e. an offer that achieves the result that, if accepted, the terms and conditions of the employee will no longer be determined by collective bargaining, collective agreement negotiated on behalf of the trade union. We'll look at those words again and again in section 145B. So the question is what is this offer? What are the effects of it, and does it have that effect? Does it have that prohibited result? And ultimately you'll see that it is, or perhaps I'll just let you read it through, the page of it.
This is made to everyone.
This is made to everyone.
Well, there must have been two different letters, mustn't there? Because there'll be those that earned less than 20,000 and got the 4%, and those that earned more than 20,000 and only got 2. So this must be a sample of the less than 20,000 letter.
I am not sure whether the two, let me just do my back. Two better.
Unless everyone earned under 20.
We think that probably possibly the same letter went to everybody, and one person who got 20,000 would read a bit about 20,000 and say, oh, that applies to me, and people who didn't.
It's just, it says in this case you qualify for a pay increase of 4%.
That's true. Yes.
Well, anyway, it may not matter, but the fourth paragraph might not be there for the higher earners, because it might be. In this case, you qualify for 2%. You did say earlier that it was the higher earners who got extra. I was slightly dismayed, but the letter suggests it's the lower earners who get extra.
Oh, sorry, did I say the other way around? Yes, that would have been very unfortunate if you were offered more to people who were already earning more. Yes, I apologise for that. So in essence, we have an offer which is about the amount that somebody earns, their Christmas bonus, a change for new employees to SSP, Sunday overtime, it's time and a half, 1.5 rather than as it was before, a double time, and consolidation of the breaks. And then at the top of page 47, no other changes to terms and conditions. So one thing that is clear is that says nothing about section 7.4 of the recognition agreement. It says nothing about how terms will be determined. It doesn't affect how terms will be determined. It doesn't say that terms will no longer be determined by collective agreement on behalf of the union.
But in this bargaining round, I understand it, the 3 bullet points at the bottom of page 46 were the only things that union had in fact been negotiating about. So it is having the effect, isn't it, that the very things that we have been negotiating exclusively under the collective agreement with your union about, we're now offering you those terms as individual employees.
They are being immediately determined
Yes.
for now by this. That's why I call it the immediate result interpretation.
No, I understand that.
But what it doesn't do is it doesn't say we're no longer talking to the union. We're not going to talk to the union about those things any longer.
Yes.
It doesn't take it out for the future result interpretation. So what the Employment Tribunal and the Employment Appeal Tribunal decided is that this is unlawful. This is a section 145B offer because it doesn't need to take the terms out of collective bargaining. It doesn't need to no longer be determined.
Well, it is. It is for this bargaining round.
Yeah, only needs to be for this round.
Yeah, exactly.
That's
Yeah.
what that's
And the EAT majority said that's within the natural language of the section which says will not be.
That's exactly it.
The 3 bullet points at the bottom, preceded by, the company is also proposing to make the following changes to our terms and conditions. Are we to read that as being whether you accept or not, this is just going to happen?
You're to read that Mr. Jones accepts the pay offer as set out in the whole letter. So Mr. Jones accepts everything in that letter. So by his acceptance, he accepts the pay and the SSP if it applies to him, and the overtime and the breaks.
But I'm not sure. Is the use of the word "our" in the 5th line from the end of page 46, is it a misprint or is it saying "our," i.e. the company? This is everybody's T&Cs going to be changed in this respect. It doesn't matter whether you accept the offer or whether you don't reply to the letter. This is what is going to happen.
It's not a matter that either party have really debated. We've both assumed that those people who signed the letter accept the changes, including those 3 bullet points, and the people who don't sign the letter don't accept the changes to those 3 bullet points. Page 48. So page 48 is the second offer, which comes in January. For those people who didn't accept the offer that was made in December, or indeed rejected it, you'll see that Ms. Mellor rejected the offer. I'll let you read that.
Yes. Okay, so the proposed changes will not be implemented without your express agreement, but we might give you notice.
So the use of "our" is emphasised in the first offer, and it's made a bit more express in the second offer.
Yes.
After that, about 90% of the workforce accepted the offers. Collective bargaining continued with Unite through 2016, went on for a long time, and collective agreement was reached with Unite on the 3rd of November 2016, and the proposals that the employer put directly to the employees in these letters were agreed collectively by Unite on the 3rd of November 2016. Unite would say, well, we have to agree it really, because employer had effectively taken the punch out of negotiations. We couldn't say, Aaron, your employers will never agree to this, because we by that time knew that over 90% of them had. But the bottom line is that these terms carried on being determined by collective agreement, and they are still determined by collective agreement. The short point is that how are Kostal's terms and conditions determined before the offers? They're determined by collective agreement negotiated on behalf of the union. That's section 7.4. How are Kostal's terms determined today? The same way. They're determined by collective agreement on behalf of the union. How were Kostal's terms determined immediately in December, when collective agreement, collective bargaining, in Kostal's opinion, had been exhausted and had not worked during the period that had been agreed for collective bargaining, October to December? They were not determined by collective agreement, because collective agreement with the union could not be reached. They were determined by direct agreement on that occasion. But did it change how terms would be determined? No, it didn't. So, and I can talk to you about the fact that the future result interpretation effectively is the Wilson and Palmer interpretation. And the immediate result interpretation is Wilson and Palmer and much more. And I'll explain why that is in a moment. Because after I just summarise the heart of the dispute, we will look at things in this order. What are the options? I've really set them out already. Second, what is the section all about? The Wilson and Palmer European...
Sorry, Mr. Van, just go back. Question 1 was...
So what are the options?
Yeah.
The two options for interpretation. Point 2 in my submissions will be why the section was enacted. Wilson and Palmer. And the enacting history. Third, I'll look at the Employment Tribunal's judgment, and the Employment Tribunal's interpretation, and say why that's wrong. Fourth, I'll look at the majority of the EAT's interpretation, and why it was wrong, and why its attempt to read extra words to the statute to try and save the realities of the position by reading in a proper purpose test, it is not appropriate. Fifth, I'll address the particular points in Mr. Brittman's skeleton argument where they aren't met elsewhere, and then we'll finish by looking again at the ordinary natural meaning of the words of the statute from the perspective of the existing recognised union and from the perspective of the union seeking recognition, if the words apply to both. A few more words of introduction. I say that the issue at its simplest is whether the section is intended to address the Wilson and Palmer mischief only, preventing the employer making an offer to its workers to relinquish or forego or reduce which terms are to be within the collective bargaining scope. Or whether section 145B goes much further and is intended to stop an employer making a one-off contractual change where that change cannot be agreed with the union. Even if the employer fully intends to continue collective bargaining over that term in the future. In our skeleton argument, that's really the page 68 and 69, and that's the introductory part and the factual background part covered. And page 71 of the core bundle is where I, for convenience, set out the legislative provisions. And so I just wanted to look at section 145B and emphasise, both Mr. Britton and I printed out and emphasised different words. So I'd like, before we start going through the Wilson and Palmer history, I'd like you to note the tenses that are used in the section. Section 145B, the heading is inducements relating to collective bargaining. We have two people who can be claimants first. First, you'll see a worker who is a member of an independent trade union, which is recognised. That's claimant number one. A worker who is a member of an independent trade union which is seeking to be recognised. That's claimant number two. So you can make an unlawful offer to somebody who is a member of a trade union which is asking to be recognised. Second, both those types of worker have the right not to have an offer made to them. So the way the statute works is to try and prevent offers being made in the first place. The purpose of the statute is so that it's not too late. The offer is illegal. It's not just the offer when it's accepted, it's illegal. When the result has been obtained, it's to try and stop the employer making an offer in the first place. And that's important because the offer is to relinquish or forego collective bargaining, and in order to try and preserve the Article 11 fundamental freedom to be a member of a trade union and to be engaged in collective bargaining, it's too late for the law to intervene once it's all been lost. And so the law tries to intervene before the stable door is closed, to stop the offer to forego collective bargaining being made in the first place. The third thing that I would invite you to note about that is that acceptance of the offer, together with other workers' acceptance of offers which the employer also makes to them. So this is intended to be a workforce-wide offer, or at least multiple offers. The reason for that is that it doesn't hurt the union if one employee is taken out of collective bargaining. It only hurts the union if lots of employees, or many employees, are taken out of collective bargaining. That's why we have it being unlawful if it's acceptance of the offer together with other workers' acceptance. So the worker has an individual right not to have an offer made to her or him, but it's only unlawful if she or he had an offer and other people too.
Sorry, I didn't pick up the significance of that. Acceptance of the offer together with other workers, acceptance of offers would have the prohibited result.
So the individual offer is unlawful to that person, but it only becomes unlawful if it is part of a wider picture of offers being made to other workers as well. If it's just made to one worker individually and to nobody else, it doesn't fall within the statute. And I say that's because the mischief of this, the Wilson and Palmer mischief, is for an employer to try and take a workforce, or at least a part of a workforce, out of collective bargaining. We're no longer going to collectively bargain for the maintenance department. So it needs to be Mr. Smith a maintenance worker plus the other maintenance workers have had the offer, it's all made to them, and it's unlawful if the acceptance of all of them has the prohibited result.
Would an offer to 3 be enough?
It would. 2 probably not, because of the use of the
The plural.
plural in worker S apostrophe. So it needs to be at least 2 others.
And the other workers in little a must be, when we refer back to 1, a member of the independent trade union.
I think probably yes, because if they weren't members of the independent trade union, it wouldn't have the result of taking it out of collective bargaining. But actually, on the immediate result interpretation, perhaps not.
It wouldn't matter.
Yes, and actually that's true. On the EAT interpretation, it wouldn't necessarily have to be other, because it's how it's determined immediately rather than how collective bargaining goes ahead in future.
But it's difficult, isn't it? Because 1 starts off a worker who is a member of an independent trade union, and then in the same subsection, albeit under little a, the word worker is used again without further definition.
Yes. I might give that a little thought to see whether I can
May
jump
not
on the
make any
bandwagon
difference. I just
or not. It may be that it
occurred
makes
to me.
difference, may not.
So it looks as though, subject to you or any of us or Mr. Brittenden having further thoughts to it, it's not enough. The section is not brought into play if an individual offer is made to 1 member, probably not to 1 member plus 1 other. It probably is if it's 1 member plus 2 others, and the 2 others need not be members.
That's potentially right, yes.
Kind of odd, that. I mean, it may be odd whichever of you is right as to the construction of all this, but it seems odd. Anyway.
It effectively, I suppose it needs to be multiple in order to meet the Wilson-Palmer threshold, but you could have a very small maintenance department with only a handful of workers, and perhaps it is important to the employer or the union that there's collective bargaining for that little department. So a higher threshold can work in the statute, and that effectively is the lowest threshold. The worker who actually makes the offer and at least 2 others.
There's the special value subclause later on in 14D4, so there might be a reason to make an offer to 1 or 2 or 3 or a small number of workers for good reason, because they have special fantastic skills which you...
Yes, not with no intention to take them out of collective bargaining, just to reward their particular performance because they have particular value. Yeah.
All right.
Then we have the first use of the future tense. If acceptance of the offer would have the prohibited result. So, at the time of the offer, we look forward into the future to the time immediately after the offer is accepted. At that time, immediately after the offer is accepted, would it have the prohibited result? That takes us to the time immediately after the offer to Miss Mellor was made by Kostal, for instance. And immediately after that, she signed a letter saying, yes, I will accept. At that point, you say, would it have the prohibited result? And then secondly, at the time of making the offer, was the employer's sole purpose or main purpose to achieve that prohibited result? And then in the definition of the prohibited result, subsection 1(2), we have the second use of the future tense. The prohibited result is that the worker's terms of employment, or any of those terms. So we have the Wilson and Palmer example, where all of the terms were taken out of forego collective bargaining for all your terms. We're not going to talk to the union anymore about any of your terms. Or, going wider than that, the government looked at a situation where perhaps just holidays were taken out, or hours, or just pay. We're not going to talk to the union anymore about pay. But we will talk to them about everything else.
You say talk about, but actually it goes on to say will not or will no longer be determined
Yes.
by. So it doesn't say will not or will no longer be negotiated about or talked about. Isn't that significant?
Determined by collective agreement on behalf of the union will be collectively bargained. Can I just come back to that point in a moment?
Of course.
Park it for a second and just look at the future tense first, because I was involved.
Of course, yes, sir.
So what I say is that the first use of the future tense, the would have a result, makes you look at the moment immediately after the offer is accepted, and at that stage, standing at the time immediately after the offer is accepted, you ask yourself the question: is it that the workers' terms, or any of them, at this point, will no longer be determined by collective agreement?
Well, not clearly.
Clearly not, but will is your problem.
Yeah.
Will not.
Will not, or will no longer. So will not, or will no longer. And the reason there's two in there is that if the workers' terms are already determined by collective negotiation, collective agreement negotiation on behalf of the union, i.e. if there already is a recognised union, then the terms are now being determined by collective bargaining, but they will no longer. But the section is more than about just recognised unions, it's also about unions seeking recognition. I've got a union seeking recognition. At the moment, my terms are not determined by collective bargaining. But I make an offer to a union member so that they will not be determined by collective bargaining, by the union seeking. So the reason we have will not and will no longer, or will no longer, is that will not is for the union seeking recognition, and will no longer is for the union which already has recognition. So the question is, at the moment of acceptance, how will, let's say it's pay. We have an offer. If that offer is accepted, at the moment after acceptance, how will pay be determined?
So we've got to look at effectively broad categories of terms, because there could be the argument, couldn't there, that, let's take for example the change in the terms in relation to statutory sick pay. If you're a new starter, statutory sick pay for your first 12 months. Now that's a done deal, that's happening, that's not going to be subject to future collective bargaining, it's done. So
No, I disagree with that.
Alright,
Lady,
don't put me right about that then.
because sick pay is one of the...
Well, that's why I'm saying, a category, or is it enough that it's just, you're saying this...
Sick pay for a new member is a term of his or her contract. All terms of contracts are by 7.4 up for negotiation. So it is, in fact, has actually happened for the rest of 2016. The union negotiated on about sick pay, and eventually they agreed with the employer. And in 2017, they say, well, we now want a different sick pay deal for new starters because this hasn't worked. It's still within the scope of collective bargaining. Nothing takes it out of collective bargaining. The union has not had its collective bargaining scope reduced. All that's happened is that in the year that agreement could not be reached through collective bargaining, the employer has effectively imposed its own will, and terms have been determined for the time being. But does that stop the union collectively bargaining over that term? No, it doesn't.
It doesn't stop them negotiating or seeking to negotiate, but it does have the effect that terms will no longer be determined by collective agreement, because if your submission is right, the employer would be lawfully entitled to take exactly the same stance in every single year to come.
Yes.
So doesn't it in practice mean that the union goes into the negotiations knowing that if we don't agree, the employer can go behind our backs and approach our members anyway?
Well, that must be right, because otherwise you have two scenarios. One which is the contract never changes because agreement can never be reached, and therefore it's unlawful to ever change the contract. So the contract employment terms just stultify. Second is the employer has to agree to whatever the union is asking for. The union effectively has the right to prevail. Those are the two options.
No, I was putting something different to you. I was suggesting the employer always has the right to prevail on your submission.
Now, on my submission, the employer does have the right to prevail, except for, let's posit the scenario, the employer goes through the motions, imposes 2% at the end of it because the agreement can't be reached, and say that we'll negotiate next year. But the union know and have evidence that the employer is actually anti-union or anti-collective bargaining and has done the imposition in order to avoid collective bargaining permanently. Its purpose, its intention, isn't to do the same next year and year after and year after. My Lord's hypothesis. In those circumstances, if the union gets evidence, and indeed I'll show you there's one tribunal case in which the union did have some evidence to that sort of, not quite as black and white as that, but to that extent, then the union can say, the reason the employer didn't agree with us and imposed was to kill off collective bargaining for good, and it was the employer's purpose to kill off collective bargaining for good. It didn't say so expressly on the terms of the offer, but that is the implication, and that can be read into the offer, and that is an unlawful section 145B, because actually what the union, the employer is doing is forcing the union to relinquish collective bargaining rights, and that's its purpose. So, the Lord's worry is catered for by the future result interpretation, because under the future result interpretation I take, it's either for the overt offer, if you accept 2% and pay is no longer effectively bargained. Sorry, I'll start that again. If you accept that pay is no longer to be effectively bargained, you will get 2%, or you will get £500. That's an overt offer, and the result of that offer is to take pay out of collective bargaining, and the employer's purpose to achieve that result. But if the offer is we're going to give you £500, and there's been evidence that the employer is anti-union, is talking down the union, saying that unions negotiating stance is rubbish, that they're totally unrealistic, totally unreasonable, they're trying to destroy the industry. The Employment Tribunal could find the reason that you gave a significant inducement or bung to the workforce, £500 per employee, was to try and undermine the union. And look, here's the evidence showing that it was your purpose to do that, because you've now achieved a situation where the collective agreement bargaining is going to be useless going forwards, and that was your purpose. So you could have an overt offer, and you can have a covert offer. Both are catered for by the future result interpretation. The other thing that, of course, caters for that position, I'm reminded, is that Article 11 is not just about freedom of association being worked out in collective bargaining, but in other ways too. the union is entitled to bring collective complaint on behalf of the workforce, and indeed it's been held by the European Court of Human Rights that in certain circumstances the union has a right to call out members to take industrial action, to strike. And so the status quo that's been there for many years is that if you have an employer who every year goes to collective bargaining and at the end of it says, nope, I'm going to stick with what I said in the first place, then the union exerts its freedom of association through its members by taking collective action, either collective grievance, collective complaint, or collective industrial action. That's how it's worked for many, many years. This interpretation of section 145B would change that whole industrial picture. That's quite clear. Is already changing it.
Well, Mr. Britton, understandably says in his skeleton argument, you can't give evidence about that, and how are we to proceed? You say it's brought about a sea change. You're entitled to point to the fact that you agree, both sides agree, that this issue amazingly has never been tested in the EAT until it came before Mr. Justice Singh, and certainly not in this court. But in a sense, that's all we know reliably, isn't it?
I have slightly dubiously put in the INEOS case into the back of the supplementary bundle, which I refer to in my supplemental skeleton, which is the only other case which is presently before the higher courts. It's stayed in the Scottish EAT at the moment, the Grangemouth dispute, where the employer and the unions reached an impasse, and the employer imposed, didn't actually say, if you agree, you can have this. What it did, it just said, we're imposing this pay rise on everybody. And the Employment Tribunal, in that case, said, well, that is actually an offer, because you're saying, here, have 2% more, whatever it was. If the employee then carries on working, the employer is accepting that offer, and therefore a binding contractual change is made through offer and acceptance.
Well, you can certainly take us to that either now or later if it.
I'll take it's a small point, but it means that there aren't way outs from the immediate result interpretation by saying, oh well, the employer can just impose the 2%, not sending a formal offer to the employees. INEOS says answer no, because that's still an offer. The tribunal in this case said, well, the employer can just dismiss all the employees and offer a new contract of employment, and that's the answer. Answer no, because the offer of the new employment contract will itself be a section 145B offer. So all of the ways that others have reached to try and then what the Employment Appeal Tribunal majority said is, oh well, we can imply some sort of proper purpose test in, and therefore even if the employer achieves the prohibited result and was trying to achieve the result, if it's got some proper purpose behind it, some rational, reasonable, good business reason for it, that gets the employer off the hook. I say that doesn't work either. You either intend the prohibited result or you don't. There's no room for rationality in the words of section 145B, otherwise it would be in there. So, if I can take you now to Wilson and Palmer, it's in the authority bundle, and it's behind tab 4. It's reported in 2002 Industrial Relations Law Reports at page 568. And if I can prevail upon you, I think the most effective way is to ask you all to read the head note, which summarises the facts and the finding. It's about 2 pages.
does? Is it the same point in all three cases?
Yes, the same tactic was taken by three separate employers in three separate situations in the same year also. But only in two different industries, printing and ports. taking you then straight to the judgment of the European Court of Human Rights, paragraph 44, on page 575. You will see that the court says the court has consistently held that although collective bargaining may be one of the ways by which trade unions may be enabled to protect their members' interests, it is not indispensable for the effective enjoyment of trade union freedom. Compulsory collective bargaining would impose on employers an obligation to conduct negotiations with trade unions. The court has not yet been prepared to hold that the freedom of a trade union to make its voice heard extends to imposing on employer an obligation to recognise a trade union. The union and its members must, however, be free in one way or another to seek to persuade the employer to listen to what it has to say on behalf of its members. In view of the sensitive character of the social and political issues involved in achieving a proper balance between the competing interests and the wide degree of divergence between domestic systems in this field, the contracting states enjoy a wide margin of appreciation as to how trade union freedom may be secured. Pausing there, so it's clear that Article 11 only requires that the employees have a right through the trade union to make their voice heard and to seek to persuade the employer to listen. Not to make the employer listen, and not to prevent the employer from doing a deal without the trade union. So the immediate result interpretation, the EAT's interpretation, goes beyond what the European Court of Human Rights say that is required under Article 11 to secure the fundamental freedom. So the question for this court is, did Parliament intend by section 145B to fix the Wilson and Palmer unlawfulness, or did it intend to go far further and grant rights to the unions that Article 11 did not demand?
And this is the 2004 Act, as was, inserting 145 ABCDE.
That's right. I'll show you the acting history in just a moment, and you'll see how section 145B followed hot upon the Wilson and Palmer judgment.
It wouldn't be surprising as a matter of principle, would it, if our Parliament decided to go further than Article 11 requires, because the 1999 Act itself, which imposes in certain circumstances an obligation on the employer to recognise a union, in fact, that's going further than this case was saying we had to go under Article 11.
Yes, although the international, the ILO had, in another setting, talked about where the employees had a majority in favour of recognition. They were pushing very much for there to be compulsory recognition. My Lord, your point of principle is right. There's nothing, I can't say that Parliament only intended to fix Wilson and Palmer, and therefore, and you're bound by that. There's nothing that, and there was some reference to Pepper and Hart style materials, but I've taken the view at this stage of appeal that the EAT was right, that there's nothing clear enough in that to show that Parliament or the Minister was just saying we're fixing Wilson and Palmer and nothing more.
I see.
But it would be wholly surprising, I say, if Parliament had intended to grant a right to prevail to trade unions when in such a covert manner in section 145B, rather than potentially putting it overtly in a compulsory
you may or may not be right about that, but I think for the moment, what you're really submitting, as I understand it, is that Mr. Brittenden is wrong when he submits in his skeleton argument that if we were to take a different view about the correct construction of this section from the EAT majority, that would put us in breach of Article 11.
That's exactly my submission. I'm showing you the limits of Article 11 because I said that Article 11 does not demand the immediate result interpretation. Indeed, it demands the future result interpretation, and the question for this court is, did Parliament, by using the word it did, intend to go further? You'll see in paragraph 45 that the court refers to other measures available under Article 11. I made reference to that before. Domestic law protection on trade union, which calls for a supported strike action in furtherance of trade dispute. The paragraph 46, the court agrees with the government that the voluntary system of collective bargaining, the essence of it is that it must be possible for a trade union which is not recognised by an employer to take steps including organising industrial action with a view to persuading the employer to enter into collective bargaining with on those issues the union believes are important. It's the essence of the right to join a trade union for protection of their interests, and employees should be free to instruct or permit the union to make representations to the employer on their behalf. Of course, if the immediate result interpretation is right, then the need for unions to take industrial action or strike action is much reduced, because they take industrial action when the employer refuses to agree to their terms. But under the immediate result interpretation, if the employer doesn't agree to their terms but takes some other result, then that's unlawful. Paragraph 47. Open to employers to seek to preempt any protest on the part of unions or their members against the imposition of limits on voluntary collective bargaining by offering those employees who acquiesced in the termination of collective bargaining substantial pay rises, which were not provided to those who refused to sign. The United Kingdom permitted employers to treat less favourably employees who were not prepared to renounce a freedom that was an essential feature of union membership. That's the right to be heard. That's the essential freedom. That's what's unlawful. The House of Lords judgment made clear domestic law did not prohibit the employer from offering an inducement to employees who relinquished the right to union representation, even if the aim and outcome of the exercise was to bring an end to collective bargaining, and thus substantially reduce the authority of the union. As long as the employer did not act for the purpose of preventing or deterring the individual employee simply from being a member of the trade union. That was the only provision that existed before 145B. So under United Kingdom law at the relevant time, it was therefore possible for an employer to effectively undermine or frustrate a trade union's ability to strive for the protection of its members' interests by making members relinquish collective bargaining. What Mr. Brittenden suggests is that line refers to employer making it more difficult for the union to get what it wants. Making it more difficult for the union to insist. Making it more difficult for the union to prevail. What that line refers to is the employer who makes an offer which brings collective bargaining to an end. And that's what Article 11 requires, and that's what Article 11 applies to. I should say that I accept, as did the government, when these sections were enacted, that it does go wider than just the Wilson and Palmer example. Turn back to paragraph 33, and you'll see what the Committee of Independent Experts under the Social Charter criticised UK law. In the quotations, the committee repeats the criticism raised in the previous conclusion. It permits employers to take certain measures such as awarding preferential remuneration to employees in order to persuade them to relinquish trade union activities and collective bargaining. And the comparable circumstances are here have an inducement to stop collective bargaining. The comparable circumstances are here have an inducement, do not take part in trade union activities, do not be a rep, or here have an inducement, do not make use of trade union services. So there are comparable circumstances, it's not just collective bargaining, and I'll show you that section 145A, B, C to F, deal with not just collective bargaining, but also trade union activities, trade union services. Whilst we're in the authorities bundle, can I just take you to tab 6? Which just reinforces this point. This is the RMT against the United Kingdom 2014 Industrial Relations Law Reports 467. The facts not need to be going through here because this is about the right to strike rather than the right to collective bargaining. It's another aspect, as you saw from Wilson and Palmer, of the Article 11 freedom, and the complaint was that the UK's requirements to go through certain procedures and processes before somebody could have a strike was a restriction on the Article 11 freedom. I just want to take you to paragraph 85. It's the sideline passage on page 481 of the report to show you what the European Court of Human Rights has said more recently about the right to prevail. Paragraph 85 starts, what the circumstances of this case show is that the applicant in fact exercised two of the elements of freedom of association that have been identified as essential, namely the right for a trade union to seek to persuade the employer to hear what it has to say on behalf of its members. We've looked at that in Wilson and Palmer. And the right to engage in collective bargaining. We've seen that in Wilson and Palmer. The strike by its high-rate members was part of that exercise. Whilst it did not achieve its aim, it was not in vain either, since it led the company to revise its offer, which the applicant then commended to its members. Although the government criticised the applicant for supporting the revised offer at the time, then reversed its stance in the proceedings, the court recognised the applicant is bound to respect the members' negative vote. Yet, the fact that the process of collective bargaining and industrial action, including strike action against the employer, of the union members who were the subject of the dispute, did not lead to the desired the outcome desired by the applicant and its members, does not mean that the exercise of their Article 11 rights was illusory. The right to collective bargaining has not been interpreted as including a right to collective agreement. See Demir and Baikara, where the court observed that the absence of any obligation on the authorities to actually enter into a collective agreement was not part of the case. Nor does the right to strike imply a right to prevail. As the court has often stated, what the convention requires is that under national law, trade unions should be enabled, conditions not at variance with Article 11, to strive for the protection of their members' interests. So, RMT and UK makes clear that collective bargaining that does not succeed does not mean that the Article 11 rights are illusory. The Article 11 freedom includes a right to be consulted, a right to meet. It doesn't include a right to achieve a collective agreement at the end of it. What section 145B with the immediate result interpretation results in is that the employer really has to reach a collective agreement with the union. It's to avoid the risk of a £4,000 fine per employee. Therefore, I say that Mr. Britton is absolutely wrong to say that Article 11 demands the immediate result interpretation. It's I say on the contrary, even more recently, the European Court of Human Rights have stressed the limits of Article 11 and the balance that needs to be made socially and politically between the rights of the unions and the rights of the employees.
I have a dim recollection from the days of Wilson and Palmer that Article 11 decisions of the Strasbourg Court in favour of trade unions and their members are extremely rare, or used to be. I don't know whether that is said. There's nothing else on the Wilson and Palmer-ish points other than what you've shown us.
No, well, the Strasbourg Court has been active, particularly in Turkey, where people get sent to prison for exerting their trade union rights, and so the right to strike and the right to collective action and so forth has been much, and Demir and Turkey is one of those cases from 2009. There have been others since. So the Strasbourg Court has looked at Article 11 much more in the light of those more acute, blatant abuses where somebody ends up incarcerated if they try and exert their rights. I say that this, and in the UK, Article 11 is used by unions in a far more nuanced way to try and push the boundaries and to redress the balance. The unions naturally say that the balance is in favour of employers because they hold the pen, they are the paymasters, they can write the contracts. Therefore, Article 11, they push and look for ways in which that balance can be redressed in favour of workers.
All right. Is that what we need for the RMT case?
Let's just look at the enacting history whilst we're in the authorities bundle. It's reviewed by the EAT. I say thoroughly, don't criticise that in paragraph 38 of the EAT's judgment. The explanatory notes are behind tab 2. Quoted by the Employment Appeal Tribunal in the judgment majority, and you'll see at the bottom of page 2 of the explanatory notes is the section relating to the 2004 Act, which made the amendments to the 1992 Act that included section 145A to F. Section 193, in July 2002, the European Court of Human Rights delivered its judgment in Wilson and Palmer. Over the page. Summarises it, the law did not prevent the employer from offering inducements to the employees in the group to persuade them to surrender their collective representation and have their terms settled in split negotiations between each individual employee and the employer. The government believes the principle underlying the decision of the court extends beyond the facts in Wilson and Palmer and is applicable to a number of other comparable circumstances. The purposes of sections 29 to 32 is therefore to secure that these provisions deal not only with the facts in Wilson and Palmer, but also with the other circumstances considered by the government to be comparable. What are the section 29 to 32 comparable circumstances? Well, section 29 has the first comparable circumstance, which is section 145A. It may be most convenient to turn back to tab 1 to see 145A. What is it? The government extended the Wilson and Palmer principle 2, and the answer is that in the same way that the worker has the right not to have an offer based on forego collective bargaining in 145B, in 145A, the worker has the right not to have an offer made to him by his employer for the sole or main purpose of inducing the worker not to be or to seek to become a member of the trade union, not to take part at an appropriate time in the activities of the trade union, and not to make use at an appropriate time of trade union services, or to be or become a member of any trade union, or a particular trade union, or one of a number of particular trade unions. So we have the extension. The government also legislates for, as the example given in the Committee of Experts report, activities, but also trade union services, which I think I mentioned earlier. And going back to tab 2, section 145A is summarised there in paragraph 195. Paragraph 200 summarises 145B, which actually just quotes the words of the statute. It doesn't shed any particular light on it. Over the page 4, section 145C sets up the time limits. Section 145D, the provisions about complaints, and so forth. Then over the page to page 5 of the explanatory notes, you can see that the government said that the sections 29 to 32 were to secure the comparable points. But section 30 is dealt with at 221. That's the amendment to section 146 to make 146 wider in scope, applying to workers rather than just employees. Over the page 6, paragraph 225, section 31, detriment for union services, being penalised for making use of trade union services at an appropriate time. So you can see that the comparable circumstances are the sections, new sections 145A to F, but also the amendments to section 146 to extend it to the other comparable problems that were raised by the government after seeing the rules of judgment. So, finally, on enacting materials, if I take it to tab 10, there is a consultation document. We've extracted the section on this part. You'll see that Wilson and Palmer features at the beginning in paragraph 3.3. Over the page, the responses from various parties, the unions and so forth, but the important parts are those in bold on page 40 and 41, because that shows the government's, the minister's mind, and therefore is admissible as a part of the enacting history of the statute. In response to the consultation, the government reaffirms its view that the European Court of Human Rights judgment requires some important changes to trade union law, especially the law outlining discrimination on grounds of trade union membership and activities. Though the instance which gave rise to the Wilson and Palmer cases are less prevalent in today's improved climate of employment relations, it would be wrong to leave the law as it is. That would mean the law is unclear. As tribunals and courts try to reinterpret its meaning in the light of the European Court of Human Rights judgment. Moreover, the government intends that, as a matter of principle, trade union law should comply with the European Convention. The government does, however, reject arguments that the judgment's discussion of the right to be heard requires any changes to the statutory recognition procedure, the right to be accompanied, or industrial action. The current law provides adequate means for unions to communicate and interact with employers on behalf of their members. The judgment makes clear that the European Court does not consider the Convention requiring particular treatment of trade unions by employers. The government also considers the judgment's passing references to the interests of the union do not require any overhaul of the law to enable unions to sue employers where their members have been discriminated against. The overriding focus of the Convention concerns the rights of individual people, not the entitlement of the organisations to which they belong. Pausing there, Lord Justice Singh's point about do we have anything from Wilson and Palmer, this is part of the enacting history which I say suggests Parliament intended to focus on the Wilson and Palmer problem only, and the government saying to the unions, we're not going to go further. And we're not going to go further than the right to be heard. Then going to paragraph 312, over the page 41, the government also confirms the law should explicitly prohibit inducements or bribes being made to trade union members to forego union rights. The bold and the underlining are from the statutory materials. The dark passage is something that we put on into at the EAT stage. So that's highlighting that we had. But the underlining is what government included. Those were the particular employee behaviours that gave rise to Wilson and Palmer cases, and they should be made unlawful. The government intends to make it unlawful for an employer to make an offer to an individual with the main purpose of inducing that person to relinquish rights to belong or not to belong to a union, rights to engage in trade union activities, or the proposed right to use union services. In addition, offers should be made unlawful whose main purpose is to induce a group of workers who belong to a recognised union to accept that their terms of employment should be determined outside collectively agreed procedures. The result is that it would be unlawful for an employer to offer an inducement to the union members in such a group to have their terms of employment determined outside the framework set by any existing collective bargaining arrangements. This limits the scope for employers to offer individualised contracts. To avoid inflexibility, however, the law should allow employers to make offers where the sole or main purpose of the inducement is unconnected with the aim of undermining or narrowing the collective bargaining arrangements. In particular, the law should give room for employers and individuals to enter individualised contracts designed to reward or retain key workers. I say that paragraph 3.12 is powerful pre-enacting material which shows the Parliament intended the future result interpretation. I've put particular emphasis on the Minister's use of the words forego and relinquish, which were used by the European Court itself, and the fact that it's about taking the terms outside collectively agreed procedures. So what the government are trying to outlaw is an employer inducing an employee to take the terms and conditions outside the procedures or the arrangements. A one-off change does not take it outside the arrangements, because the arrangements remain. A one-off change does not take it outside the terms and conditions outside the procedures, unless the procedures are removed. Or unless, in the example I discussed with Lord Justice Singh, there's a covert attempt to take it outside the procedures. So it's in effect, taking it outside the procedures in effect. This part of the enacting history, in my submission, makes it clear that the EAT's interpretation applies section 145B to far, far more cases than Parliament intended. Parliament was trying to protect industrial arrangements, collective bargaining arrangements, stopping employers making offers, say, take your terms outside these arrangements, and the term the government uses is moving on to individualised contracts. An individualised contract is one in which the union has no part to play.
Let's suppose you're right about that as a generality, but does your submission require the consequence that it's only caught by section 145B if it's going to have that effect permanently, so forever into the future?
Forever into the future, and we rather got tied up with temporary impermanence in the EAT. Yes, forever in the future until it changes again. So I say it's not about permanent, because employment contracts are never permanent, because they can always be changed again.
Right, well, if that,
It changes it
right.
permanently for the time being.
What might be said against you is that it does alter the framework for this collective bargaining round. That's exactly what it's
So-
achieving.
What I say is the framework is unchanged, because the union has the right, the employee has the right for the terms to be determined in a framework ongoing. The framework is used. At the end of that period of negotiation, the framework, for whatever reason, does not work. But the framework persists. The framework continues. And at the day after the offer is accepted, if one asks the question, is there today a framework or arrangements or procedures by which affect your terms and conditions? The answer would be yes. Those arrangements are still there. They're still in place. They're in full force today. The fact that I've just agreed with my employer 2% doesn't change the arrangements at all. What Wilson and Palmer, as you saw, was all about, what section 145B is all about, is an employer saying to the employee, in return, I'm going to offer you this in return for a change to the arrangements or procedures. And so the union are out forever until the arrangements are put back in place.
And before you leave 3.12 of this document, I wonder whether it's really any use to you. It's not hostile to you, your argument, but you pointed to the word forego in line 2 and relinquish in line 6, and they are certainly permanent acts, but that part of the paragraph is dealing with what became section 146, isn't it?
And 145A, yes.
And 145.
And
145A.
the words of 145A are very similar to, not quite identical, but very similar to 145B. So I say what source will do, what source will gander.
But then it goes on to the sentence beginning, in addition,
Yes.
offers should be made unlawful whose main purpose is to induce a group of workers who belong to a recognised union to accept that their terms of employment should be determined outside collectively agreed procedures. And we come up to the ambiguity. You say that means determined for all time, and Mr. Brittington is going to say determined on this one occasion.
Oh. The offer, I make an offer to you, my lord. Will you accept that your terms of employment should be determined outside collectively agreed procedures? If you say yes, and after that you've accepted that, your terms and conditions will no longer or will not be determined using collectively agreed procedures. They'll be determined some other way. I say to you, will you accept, we have collectively agreed procedures, they haven't been successful this year, will you accept 2%? You say yes. Doesn't affect how your terms and conditions will be determined after you say yes. They'll still be determined by collectively agreed procedures because they're still there. So I say the use of the word procedures and arrangements shows the longevity of the prohibited result. Perhaps while we're at the back of the authorities bundle, I can take you to the Harvey. I don't say that Harvey and which is tab 8 and tab 9, tab 8 first. I don't think we can put either aside. We put particular weight on this is that Harvey, although it's the leading text, hasn't had a lot of time to. This isn't time immemorial. This is an editor's recent comment on a case that you're considering. But I say, still, it gives some textbook academic assistance to the conundrum that we are facing. Tab 8 is the introduction by the editor of the Statute section. On page 2 of the extract, you'll see this section headed General. Do you see that, my lord? Just over the page. Sections 145A to 145F were added to deal with the issue of sweetener payments to persuade workers to surrender their collective representation and to move to individual contracts. This is in the Wilson-Palmer litigation, which culminated in the judgment of the UK Court of Human Rights. The existing provisions, detriment relating to union membership and activities 146 below, was incompatible with Article 11. In reviewing the judgment, the government took the view that reforms needed to go beyond the facts of the case itself and so introduced sections 145A and B, which give general rights not to have offers made of such payments in order either to give up union membership or union services or to give up having terms and conditions set by collective bargaining by the Employment Tribunal. So far, so uncontroversial. One goes over page to tab 9. You'll see the section from Harvey on section 145B itself. Doubtless a practical necessity for the employer to offer some sort of inducement or sweetener to tempt workers away from collective bargaining. The workers are unlikely to surrender the security without it. Doubtless, therefore, the claimant will in fact have been offered some inducement or incentive, and doubtless that will put in evidence as tending to prove an improper purpose on the part of the employer below. But there's no legal requirement to prove an inducement or incentive in order to substantiate a claim under this head. The heading or side note of the section is indeed inducements relating to collective bargaining, and also in the Commons Committee, the Minister explained the provision proposed to create a right for members of recognised unions not to be offered inducements to abandon collective bargaining, but there's no reference to inducement in the body of the text. The section merely looks at the purpose and potential effects of the offer made by the employer. I accept exactly that the statute wording is about offers, but the reality is that offer would normally be the offer of something good to give up collective bargaining, otherwise why would you? Theoretically, therefore, the employer simply invites the workers to agree to switch from collective bargaining to individual contracting. He has made an offer to them, at least in the contractual sense of offer and acceptance, the purpose and effect of which would be the abandonment of collective bargaining, and all the elements of the claim are made out. That is, however, unlikely to happen in the real world of industrial relations. This is paragraph 794. As just indicated, assuming several offers have been made by the employer, it's then necessary to consider their purpose and effect. What was the employer's purpose in making the offers, and what would the effect if all the workers were to accept the offers? The question is proposed in relation to what the actual result. Over the page, in particular on our two interpretations. The prohibited result is that the terms of employment or any term of employment of workers concerned will not be or will no longer be determined by a collective agreement negotiated by or on behalf of the union. There is room to argue that the use of the word will means that it is not sufficient that following acceptance of the offers, one or more terms of the contract have been agreed otherwise, have been collectively. Rather, it can be argued that the employees must agree that in future one or more terms will not be settled collectively. Indeed, that was the situation in the Wilson and Palmer cases, which section 145B was enacted to change. Against that argument, it can be contended that once, for example, some employees have accepted the employer's direct offer of a pay increase, from that point on, unless and until a further new pay rate is agreed, their pay will be determined by their direct non-union agreement. However, section 145B applies in two situations. First, where the union is already recognised and the employer makes an offer which has the prohibited result that some workers' terms will no longer be determined by a collective agreement with the union. Second, where the union is seeking recognition and the employer makes an offer which has the prohibited result that some of the workers' terms will not be determined by a collective agreement with the union. Just pausing there, that's the point I think I made earlier about the two different parts of the wording. Going back to it. In the latter case, the workers already have non-collectively bargained terms. So presumably, the prohibited result will only occur if the workers agree, I will not have my terms determined by collective agreement with the union which is seeking recognition. The employer would surely not be achieving the prohibited result merely by agreeing an annual pay rise direct with those workers while the union was still not recognised. If that is the case, then in the other situation, where the union is already recognised, it can be argued that the agreement needs to be similar, along the lines of, I agree no longer to have my terms determined by a collective agreement with a recognised union. This argument was apparently not advanced in the single reported case on section 145B, where the EAT by a majority concluded that section 145B applies in a case where the union is already recognised, even if the non-collective determination of that contract term is a one of Kostal. It submitted that the conclusion of the EAT is the better one. The mere fact that section 145B can only apply to a narrower range of circumstances in a case where the union is merely seeking recognition should not constrain the effect of the section in a case where the union is already recognised. Indeed, to hold otherwise would make it too easy to evade 145B. Note, however, that the issue of future raises its head again when one comes to determine the employer's purpose in making the offer. Also, pausing there, the editor of Harvey is with me all the way and then sees Kostal and then turns against me, so never mind. But what I say, that last line is flawed on a statutory construction approach, because if the words will not mean that in those circumstances with a union seeking recognition, because they're using the same sentence as the will no longer, the two can't mean fundamentally different things. And so one is constrained by the other, or at least one needs to read it so they both have a consistent reading. Otherwise, the section would have two parts to it, wrapped up in one sentence, one which takes you down one direction, one which takes you down another. So I disagree with the editor of Harvey when he says, well, or she says, well, the EAT concluded better. That argument is a statutory construction argument, and therefore, if the words only work in one way, relating to unions seeking recognition, they must work in the same way for unions who are recognised. So that's I think maybe I'll just take you to, I'm not sure Mr. Whitman may have if you read yourself the rest of Harvey, which is about purpose, section 796 onwards. It's me that tramline that section. I did it just because you'll see that Harvey talks about the narrow view and the wide view. It's a different way of labelling the competing interpretations. We put the future and the immediate result interpretation. I realise that time is getting on, so I ought to push on to looking briefly at things that we're appealing against, which is the Employment Appeal Judgment, the Employment Tribunal judgment. I can take you to page 115 in the bundle. I should say that I won't be spending a long time in the Employment Tribunal in the Employment Appeal Tribunal because it's a question of construction. And therefore, really, it's a matter that you can look at afresh. Asking you to look at in detail the facts found at page 115 of the core bundle. You'll see that that's the facts set out by the tribunal. They mention a paragraph 5.6, the recognition of procedural agreement that I've shown to you, and the sections of that which I've shown to you. They talk about the collective negotiations that took place as they were supposed to between the October and the December, page 117, 58, 59, 510, and the offer that was made over the page 119, they talk about the allegedly unlawful offer, the offer that they found was unlawful, 10th of December, which I've shown to you in the supplementary bundle, and the subsequent one, which I've shown also in the supplementary bundle. Of interest in the facts, on page 120, 517, we can see that at the 14th of December pay negotiation meeting, which is immediately after the first offer, the union complained about sending a letter out to all employees bypassing the collective bargaining agreement. The tribunal went on to say subsequently, in the meeting, Mr. Coop indicated that if the respondent took out the provision about changing breaks, then he could guarantee he would get the pay offer through. According to the note, Mr. Coop suggested that change to the break could be imposed later. It was noted that there was going to be further consultative ballot as to whether there should be industrial action, and so forth. So, on the facts of the case, it's all rather regrettable because the one change that the employer was choosing to make because it felt it had to, according to working time regulations, was the one that the union said that was the stopper in this particular fact, this particular case, and the rest of it they could agree to. But there it is. That's just one of those unfortunate parts of the fact. You'll see at the end of that page, 125.20, by the end of December, the parties were at stage 4 of the procedure in the collective bargaining agreement, whereby the issue could be referred to ACAS for conciliation. In anticipation of that, both sides set out their case in writing to ACAS. And then you'll see over the page 121, 523 is the second offer that I have showed you. On the 29th of January 2016, Mr. Johnson wrote to Mr. Coop. He did not accept that there had been a breach of the 1992 Act. He said it was never the company's intention to induce people to opt out of collective bargaining. The only reason for making the offer initially was so that the Christmas bonus could be payable before the end of the year. There had been nothing in the offer to suggest the acceptance would mean agreement that there would no longer be subject to collective bargaining. So you can see that the employer was taking the future result interpretation right at the stage of talking to the unions. Over the page 122, it was not until 3rd of November 526, it was not until 3rd of November 2016 that a collective agreement was reached in respect to pay 2015, compare documents to the pages X to Y, save for the by then relevant issue of the Christmas bonus. The collective agreement endorsed the pay proposal which the respondent had put forward in November 2015, together with 3 changes to terms and conditions. Over the page, one sees that the submissions, Mr. Brissenden, the second paragraph down on page 123, we are reminded that section 145B2 applies to both the worker's terms of employment or any of those terms. That again indicated that it was not necessary to be a complete cessation. We were invited to take what Mr. Britton described as a granular approach as to which terms had effectively been taken out of the sphere of collective bargaining. It would be sufficient if just one of the very many collective bargaining terms would not be determined by collective agreement. I actually would adopt that. If the offer, if accepted, took the term out of the sphere of collective bargaining, so it was no longer in scope of the collective bargaining agreement, then that would be a section 145D breach. I say it's the immediate determination which doesn't. Going now to the tribunal's conclusion, it's at page 126.
Yes.
You'll see that they need to interpret the scope of the legislation, correct. They've taken into account the history of legislation, it's carefully set out in the Britain skeleton argument, the explanatory notes to the 2004 Act indicate the purpose of the legislation was not to give protection not only to workers who found themselves in the position of Mr. Wilson as Palmer, whose employees were striving for their trade unions to be recognised, but also to workers in circumstances considered by the government to be comparable. The explanatory notes do not give any indication of what those comparable circumstances might be. So it looks as if that widening in the explanatory note led the Employment Tribunal's error into taking the immediate result interpretation, whereas we've seen that section 145A and the additions to 146 were what the government was saying were the comparable circumstances. Over the page, 127. You've got Mr. Vaughan, who then is for the respondent and his contentions, and we'll talk about the St John of God Care Services. That's the dismissal and the engagement point. I've already mentioned that, I don't need to mention it again. At the bottom of that page, we agree that the prohibited result is about terms being changed permanently to the extent that it uses the word determined, that is, finally decided. However, we find that that is exactly what the offers were intended to achieve. As Mr. Johnson accepted for examination, when Mr. Nigel Jones, the recipient of the sample 8th of December offer we have, signed his letter, he was agreeing that he accepted the pay offer set out in that letter. A bargain, as Mr. Johnson accepted, had been struck. Correct. From the date of acceptance, Mr. Jones' terms with regard to Sunday overtime, day rates and pay would be governed by that bargain. Accordingly, the respondent had achieved a permanent solution than the temporary one. True, they were governed at that time by the bargain. They were governed. But how will they be determined? This is what the Act asks. Not how are they governed or how would they be governed, but once you've accepted, will they no longer be determined? So you're looking into the future, and what the tribunal did is they used the immediate interpretation. And if you look over the page, it's quite clear that they say, whilst there would ultimately be a collective pay agreement concluded in November 2016, in law that did not alter the fact that the individuals who accepted one or other of the individual offers had already had their terms determined on the basis of the individual agreement, rather than a considerably later collective agreement. So it uses the tribunal uses the past tense. They had their terms determined. The tribunal didn't say at the moment of acceptance, we have to look forward to whether the terms will no longer be determined in that way. So that shows, and then we get on to the purpose point, but because the prohibited purpose is the same for both the result and for the purpose, the problem, the error that I say affects that first part, then obviously flows through when the tribunal looking at the employer's main or sole purpose. They have to get the construction of prohibited result correct for both part A and B. So it affects both of that. Looking then at the Employment Appeal Tribunal's judgment, and if I can invite you to turn to page 29 in the core bundle. You'll see, I say up problem at the beginning of the Employment Appeal Tribunal, maybe because of
Should we use the reported text?
report, you can use the report, yes,
Which is in
in the
section 9 of the authorities bundle.
yes. So in paragraph 3 on page 770, at letter H, there's a section which the EAT says moreover. Do you have that, my lord?
Yes.
Moreover, as the company makes clear in any event, there is really only one ground of appeal raised in relation to liability. It is that the Employment Tribunal erred in law in construing the prohibited result in section 145b2 to mean that if direct agreement between workers and employer was reached in relation to one or more terms, which would, as a result, no longer be determined by collective agreement, that is sufficient to constitute the prohibited result. You'll see there that the EAT has perhaps the wrong language. Actually, that's my submission. That's not what the Employment Tribunal said. It's not what the EAT concluded. Because if the agreement reached was that one or more terms would no longer be determined by collective agreement, well, that's the future result interpretation. That looks forward in the future because the word would is the future tense. So the Employment Appeal Tribunal mischaracterised the submission, the error, right at the outset. But it's not, we are dancing a little bit on the head of a pin, because as the Employment Appeal Tribunal said, because yes, what's unlawful is the offer, and because you're looking forward to what would the prohibited result be at the time of the acceptance, you're already looking into the future. But what the Employment Appeal Tribunal failed to do is realise there were two future tenses. And this first would look forward to what happens at the time of the offer, and at that time you look again into the future to decide whether terms will not be determined or will no longer be determined. The key part of the Employment Tribunal, sorry, the Employment Appeal Tribunal judgment is, first of all, section 40, page, paragraph 35, which is at page 779. The Employment Appeal Tribunal rightly says that the provisions were introduced in response to the ruling in Wilson-Palmer. The 36, the particular mischief was identified by the Strasbourg Court in paragraphs 41, 47, 48. Indeed, also paragraph 46, which I took you to, which the Employment Appeal Tribunal missed out. And then in paragraph 37, I'd say the Employment Appeal Tribunal went into error by saying, in other words, the Strasbourg Court held that states have positive obligations to secure effective enjoyment of Article 11 rights. And if direct offers outside collective bargaining process can be made and would lead to a less favourable treatment of workers who do not accept, that acts as a disincentive to the exercise of Article 11 rights and allows employers to undermine or frustrate a trade union's ability to strive for the protection of its members. I say, the reasons I submitted earlier, that goes beyond what Wilson and Palmer and RMT UK say that Article 11 requires. It isn't any direct offer outside collective bargaining, because, as Wilson and Palmer and RMT makes clear, you don't have to get collective agreement for Article 11 to be discharged, and therefore an offer which is other than by collective agreement is permitted by Article 11. So the EAT thereby gets Wilson and Palmer wrong, thereby gets Article 11 wrong, and that, in my submission, is what then leads it to take Mr. Brittenden's submissions and the immediate result interpretation rather than the Wilson and Palmer interpretation, which is the future result interpretation. That can be seen when one looks at the Employment Appeal Tribunal judgment at paragraph 48. Page 784. They agree, paragraph 49, the words are the starting point. They ask the question in paragraph 49, the majority. Then paragraph 50, we consider, in agreement with Mr. Brittenden, that too much is made in Mr. Burns' argument of the use of the future tense in the phrase will not or will no longer, and that seeks to create a false dichotomy in advancing the two competing constructions referred to above. It's self-evidently the case that an offer, once made, can only be accepted subsequently, so that any acceptance viewed at the point of an offer is being made in the future. We explain this, we consider this explains the use of the future tense in 145B. It explains the use of the word would, it explains the first use of the future tense, but it doesn't explain the second use of the future tense. Will not or will no longer. It's a double future tense, and the EAT overlooked that. Paragraph 51. Correct that it's Wilson.
Just a minute.
Sorry.
Double. Can you just explain the phrase double future tense?
Double future. Go back to the section, tab 1, in the authority bundle.
Or earlier in the judgment.
Or, yes, wherever you can see the whole of section 145B, we have the first future tense in subsection 1A, acceptance of the offer would have the prohibited result. So you're looking forwards to what would happen at the moment of the acceptance. That's the future tense the EAT says is inevitable.
Yes.
But at that point, it's got to have, at that future time, the prohibited result. The prohibited result uses in subsection 2, will not or will no longer. So you're looking into the future once you're already in the future. And the EAT overlooked that. Must be said, I've spent considerable time on my feet on these words. I mean, the idea that employers and unions can put this into daily practice when they're engaged in collective bargaining is just an extraordinary proposition. But here we are. That's where we are. Going back to the EAT, I should say that the way that the EAT's judgment leaves the matter is that you look forward to the prohibited result with the use of would, then the prohibited result would be is that the workers' terms of employment, where those terms are no longer determined by collective agreement. At that point.
Are or will no longer. Are or will no longer be.
Well,
if you're right.
If I'm right, it would be, but if the EAT are right, then the Parliament would use the present tense in the result, not the future tense. Because the present tense would have done the trick. You no need to have the will. You could just said, acceptance of the offer would have the prohibited result. The prohibited result is the workers' terms of employment are no longer determined by collective agreement. And as of that day, they wouldn't be. They'd be determined, as my Lord Justice Singh pointed out, by direct agreement. chose to put the second lot of future tense in, and that's why we are looking at the Wilson and Palmer interpretation. Are you taking these terms out of the scope of collective bargaining?
You say it's a second one, but could it not be read as being really the same as the first one? In other words, the prohibited result is that you're envisaging a hypothetical situation in the future where the offer has been accepted. So, but you have to judge things, because what's being made unlawful is the making of the offer. So you judge things as at the date of the offer. Will the prohibited result occur in the future? And that could explain why the prohibited result is expressed in the future tense will not or will no longer.
Once you've got yourself into the future, I use the word would. Present tense absolutely does the trick, because the only question is, on the day after acceptance, are the terms on that day determined? Are the terms on that day governed by collective agreement or not? And the answer would be they are not on the moment of acceptance. They are not. They are no longer. They are not or are no longer governed. But we haven't got that. We've got will not or will not no longer. And that is the clue, which I say means that Parliament was intending to fill the Wilson and Palmer gap and make sure that employers didn't take terms out of collective bargaining by inducing employees. And that was all that Parliament intended to do. Because Parliament intended to cover the union that was seeking recognition, that would have to be, well, it only makes sense with future result interpretation, I say, when one looks at the union seeking recognition. I know that we are a union, recognised union in the Kostal case, but as soon as you look at the union seeking recognition, the immediate result interpretation makes no sense. Because of course they're not determined on that day. Why would they be? There's no expectation they would be. It can only be, as Harvey pointed out, that you're looking into the future. If you're looking into the future for the union seeking recognition, then you must be looking into the future for the union who has recognition.
Is it part of your submission, Mr. Burns, that in the scenario we have, in our case, which is where the union is already recognised, that the only part of the formulation in subsection 2 which is relevant is the words in brackets, or will no longer?
That appears to be the correct reading of the passage when one looks at recognised union, unrecognised union, will no longer, will not. The two things. Yeah. It's not. I can't say that it is beyond all venture clear at that point. I wouldn't make it that. But those two things hang together so neatly that I have to agree with Harvey. I think, I'm not sure it's common ground. Maybe, I suspect it's not common ground because, of course,
I doubt if it's
system
common ground.
if you could attach will not.
Yes, I think
as
at the heart of the reasoning of the EAT majority is that even in a case where there is already a recognised union, the phrase will not will apply.
But even in those circumstances, will not looks, will no longer is really clear. Because it means that they're no longer going to be determined that way. But will not be determined that way, why should it be any different? So I say if you're going to apply the words will not to the recognised union, it should be consistent with words, with the result of if you apply the words will no longer to them. Why would Parliament intend the words will no longer to have a narrower meaning than the words will not? So the EAT should have, I say, construed will not consistently with will no longer in the effect, in the way that Harvey took you through the argument and then stepped back from it at the end by saying we shouldn't allow one set of words to be constrained by the other. I said absolutely we should, we must, because the words of the statute in the same sentence must mean the same thing. They can't mean something different. I say that the time limit point takes us nowhere at all. Well, this is paragraph 454 of the Employment Appeal Tribunal judgment. The bottom line is that employment tribunals will often have to look in a whistleblowing case or discrimination case into the employer's potentially unlawful animus at a time within 3 months when they haven't got the evidence of what the employer's animus is in a whistleblowing case, in a discrimination case. And the fact that they have to look into the employer's purpose within 3 months is neither here nor there.
In any event, don't you have to ask yourself all of these questions as at the date of the offer? And surely, if the terms of the offer are the unlawful ones, there's no reason why somebody can't make their claim within time.
That's true. What the EAT said is that it often won't be clear. The employer's purpose may only become clear in the months thereafter. When the time of the offer,
Yeah, that I understand.
one has to go on inferences and context. And in the ENEOS case, what was said was, oh look, here's some emails which show that the employer behind the scenes is finding the union very disagreeable. And so that was deployed in the ENEOS case as saying, although this was just a pay imposition, you can find some of the prohibited purpose in here because this was a pay imposition, but what they were really at after was doing away with collective bargaining. But as the ENOS case employed the Kostal immediate interpretation, they didn't have to look forward into the future result interpretation because they thought the immediate result interpretation was correct. And so the tribunal in that case would have got it wrong. But in that sort of circumstance, playing with that sort of evidence will go into next. On page 787 of the EAT judgment, paragraph 60, the EAT looks at the mandatory factors in 146D when concerning the purpose. You've got those set out to you earlier in the judgment. At paragraph 32, or they are kept behind tab 1. My submission was and is that because you're looking at when the offers are made, has the employer recently changed or sought to change arrangements with the union for collective bargaining? That's looking at the future result interpretation. Have arrangements changed? It's the same thing that we were looking at in the DTI government note about changing collective bargaining arrangements. It points to that, taking things out of the scope of collective bargaining, taking things out of the arrangements. And B, that when the offers were made, the employer did not wish to enter
Well,
into arrangements.
before you go on to B, what about did not wish to use?
Yes. So there's any evidence that the arrangements are themselves antithetical to the employer. The employer doesn't like the arrangements, either because they wanted to change them or they didn't want to use them. That would be an indication that the employer was against the arrangements. Not that the employer wanted to impose 2% because it couldn't get anything else agreed with the union. It's looking at the scope of collective bargaining in the future. Those collective bargaining arrangements, whether the employer is indicating some evidence that it's against the arrangements. Not that it can't agree on that day what the pay should be, or what the sick pay should be, or what the overtime should be. The Employment Appeal Tribunal said they don't agree that the facts were consistent with the future result interpretation, and they said they focused on the circumstances that exist when the offers were made, and underline the sensitive nature of the inquiry. Section 61, so paragraph 61 of the Employment Appeal Tribunal is what in some ways is most concerning at the moment to the present state of affairs, because the Employment Appeal Tribunal talk about the infinite spectrum of facts that may have to be considered in a 145B case. One end, cases where the employer has sought to change collective bargaining arrangements and then, without entering into collective negotiations or precipitately in the midst, and absence of pressing business aim makes offers which would be effect that all employment terms will be agreed directly if accepted. The other end of the spectrum will be employers who engage in lengthy, meaningful collective consultation and reach an impasse before considering making direct offers who can demonstrate a strong history of operating collective bargaining arrangements with the union, have no wish to avoid entering into such arrangements when the offers are made. Cases where employers show genuine business reasons unconnected with collective bargaining for approaching workers directly outside the collective bargaining process. Difficult cases in the middle. I would submit that all cases will fall into this category. Certainly all realistic cases. Difficult cases in the middle where the employer has mixed aims or objectives that it seeks to achieve, or the evidence is unclear. The question in each case is a question of fact and degree. As with all other different cases where the employer acts reasonably and rationally and has evidence of genuine alternative purpose, tribunals are likely to be slower to infer an unlawful purpose. In cases where the employer acts unreasonably or rationally with no credible alternative purpose. And so that's the answer to the veto point. But the problem is this. So the employer is saying, can't afford any more than 2%. Very sorry. The union is saying, this is outrageous. Look at cost of living. 3% is the least that you can possibly offer. You're outrageous. And the employer is saying, 3% is outrageous. And they're both taking that position. Absolutely common. Absolutely bog standard for industrial relations. Both saying the other side's unreasonable. The Employment Tribunal, on the EAT's analysis, is going to have to get into the fray. It's going to have to step into the fray and decide the rights and wrongs of each collective negotiation.
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the West Green building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
Well, normal business is at 1 o'clock. Well,
Yes.
We need to stop talking in any event.
Attention please. Attention please. This is the Incident Control Officer. An evacuation is in progress in the West Green building. Do not enter this area until further notice. Your area is not affected. Please continue normal business.
This happens quite a lot on the stroke of one on various days in the week. Sometimes it's drill and sometimes it's a drill. If it goes on and on, we'll break off and come back at 2. But if we manage to get a few more sentences in edgeways, how much further have you got to go?
So I've only about, in the last 15 or 20 minutes probably.
All right. Well, that's fine because you had the burden of taking us through the statutory material and so on. So
I'll probably allow it to expand to half an hour by the time I've done some more work.
well,
I'll leave it
try not to because we've got to give
yes.
Mr. Brittenden a chance to make his points, and then you may want to reply at the end. All right. 2 o'clock.
All right.